and additional ones I know for the British Computer Society, and I'm sure the Society for Computers and Law. We're very grateful to him for all the efforts he puts in. And he's going to talk to us this evening about open source and all the legal aspects associated with that. And just before I hand over to Dai, just a couple of things to say. First of all, this presentation is being recorded. I believe it's going to be published on the British Computer Society website. Is that right? Yes, yes. Just to let you know that that is actually happening. And the second thing is, please could you make sure you sign the attendance sheet at some stage before you leave. So now I'm not going to say anything else, just hand you over to Dai.
Thank you very much indeed, Sybil, and good evening, ladies and gentlemen. They say you should never start so I'm not going to apologise to you, but I am going to apologise to the viewers who are listening to this at home on the basis that this is a lecture for the people in front of the audience, and I hope it's of interest to people who may be subsequently listening to it, but primarily this is a lecture to you, and I'm happy for it to be interactive. If any of you have any questions as I'm going along, please don't hesitate to stop me. The worst response you'll get is that I'll deal with the questions raised later, but I'm more than happy to take questions as I go along. And it's quite ironic, I thought, talking tonight about open source software in such a closed environment. What do I mean by a closed environment? Well, congratulations to you all in coming through the multifaceted layers of security to get through here. In my days, universities you could just walk into, but it seems that that's the case these days, so congratulations for actually finding your way here. Open source, what am I going to talk about? Well, first of all, I'm going to talk about copyright, because I appreciate there are some people in the audience here who are familiar with copyright, but probably the majority of the audience, copyright is not their, if you like, natural subject. So I'm going to talk a little bit about copyright, and then I'm going to talk about software in the context of copyright. Software is protected in a number of different ways, confidential information, patents, but it's copyright is the primary protection for software. So copyright in the context of protecting software. And then I'm looking at licenses and, of course, open source software and open source licenses. And then I'm going to talk to you about what I call the real issues of open source. There's a lot of hogwash that's talked about, particularly in the legal context, about open source. But I'm going to tell you life as it really is in the context of open source software and the legal issues relating to that. So without further ado, let's talk a bit about copyright. And copyright is ancient. It's been around since the Statute of Queen Anne, which always amuses me since we never had a Queen Anne, but that's a different story. Point is, it's been around for a couple of hundred years, long before anybody ever thought of software, let alone protecting software through copyright. We've had the law of copyright, say, for a long time. It was developed originally for books and subsequently developed for photographs, films, buildings, the plans of buildings are protected using the law of copyright. Sculptures are something else which is protected, another example of an artistic work which is protected through the law of copyright. And finally, of course, for our purposes, computer programs are also protected by the law of copyright. That latest extension in terms of computer programs is fairly modern, though. Until 1988 actually, 92, before we didn't have copyright protection for computer programs in the law of in Europe. In fact, the legislation in the UK was originally 1985, but even in the UK, prior to 1985, there was a serious academic debate as to whether copyright extended to computer programs. Now it's covered statutorily, extended if you like, copyright is extended to cover computer programs, not only in the UK, but as I say, throughout the whole of Europe. There are certain, if you like, hoops that one has to jump through in order for there to be copyright. First of all, the work has to be original. Well, the concept of originality is not a particularly high threshold. There are one or two people here who are taking notes of what I'm saying. Those people who are taking notes, each of you will have separate notes, different notes. You'll be writing down separate bullet points from the points and the matters I'm talking about. Each of you will have an original set of notes. The fact that it's come from the same source is neither here nor there. Originality, as I say, is a very high, is a relatively low threshold. You need to be a qualifying person. By that I mean you have to be a resident, a citizen of a country which protects copyright and which we, in the United Kingdom, respect the copyright of. What do I mean by that? Well, copyright is based upon international conventions. Two important international conventions, the Berne Convention and the Universal Convention. And the deal under these conventions is like this. Well, you know, we don't like the French very much, but okay. But we say to the French, you've got this thing in France that you call copyright, we've got this thing in England which we call copyright. I tell you what, we will protect your French citizens' copyright in England if you protect our English citizens' copyright in France the same way as you protect your French citizens' copyright. It's a quid pro quo. Provided you are in the club, by which I mean the country ascribes to one or both of these conventions, then you are, in that sense, you are a citizen for which your copyright is protected. But if there's anybody here from South Sudan, oh, okay, well, I'm not surprised. Well, in that case, you won't have any copyright convention. I remember copyright protection. I remember about 15, 20 years ago, I was talking to a citizen from Jordan about copyright, and she'd written some software, and I said, I'm sorry, but you don't have any copyright protection. And the reason was because at that point in time, Jordan was not a member of the Universal Convention. You have to look fairly hard to find countries these days that are out with the protection of copyright, but there are a few countries. So South Sudan is probably one case in point. But most countries in the world people have a problem. You don't have to register copyright. Copyright exists automatically. As soon as you write a book, as soon as you write an article, as soon as you write a computer program, you will automatically have copyright in that book, in that computer program. You don't have to do anything. Unfortunately, there is a proposal to try and tweak that in the UK. We'll wait and see what happens. That would be a very retrograde step if it did happen. That was one of the government did, as it always does. Whenever we get a new government, the first thing they do is let's have a consultation on intellectual property laws and see where it's wrong. So, in inverted commas, one of the things they thought would be wrong was that there should be some sort of register of copyright. I don't think anything will happen with that, but there is a half a proposal floating around in government at the moment to do something about that. But at the moment, no registration whatsoever for copyright, and let's hope it stays that way. In the US, until about 10 years ago, you did have to register to obtain copyright. Doesn't exist anymore. Again, in the US, now copyright exists automatically. There are some weird extra rights that you get, I won't bore you with, if you do register in the US, but you don't have to register. You have to, again, look fairly hard before you find a country where registration is necessary in order to obtain copyright. And Cyprus, when I last checked, is a case in point. Most countries, most commercial countries you're ever going to come across, automatic. As soon as you write for copyright, not only do you have protection in the UK, but you have protection in all the other countries that respect, if you like, copyright ascribed to one of these two conventions. There is no monopoly in the work that you produce. What do I mean by that? Well, Microsoft has a word processing program, but it doesn't have a monopoly in word processing programs. WordStar, WordPerfect are other word processing programs. Because copyright only protects the manifestation of the work, not the subject matter. What do I mean by that? Okay. Who here has not seen West Side Story? Come on, you're all shy. Okay, all right. About a third of you. All right. Well, if you want me not to ruin West Side Story for you, you can leave the room now for 5 minutes. So, to you the viewer, switch off for the next 2 minutes if you don't want me to ruin West Side Story for you. Okay, I'm not going to ruin West Side Story that much. For those of you, for the half of the audience who has been to West Side Story, can one of you who's been to see West Side Story tell me what the plot of West Side Story is in 3 words?
Romeo and Juliet.
Is the correct answer. Thank you. Romeo and Juliet. Now, obviously Shakespeare had been long dead when, I always forget the name of the person who wrote West Side Story. Does anybody know West Side Story? Gilbert? I can't remember who wrote West Side Story? I haven't been to see it, so I've got an excuse for not knowing. The copyright of Shakespeare was not breached when the authors of West Side Story wrote West Side Story. Why? Because, well, we all know what Romeo and Juliet is set in Italian city, etc. But West Side Story is at Chicago or New York, Gunland, which is Chicago or New York. I don't know which one it was.
I think it was
New York, okay. New York seems to be the consensus. So, New York, Gunland. The manifestation, the fact that the plot was similar, is neither here nor there. Both of them have separate copyrights. Or put it another way, if Shakespeare had written Romeo and Juliet more recently, and it would still be within the copyright period when, was it Solomon or whatever, wrote West Side Story, it wouldn't have been a breach to write of that copyright to write West Side Story, because although the subject matter is similar, the manifestation is completely different. And copyright protects, as I say, the manifestation, not the underlying subject matter. That's what I mean by it's not a monopolistic right in that sense. Anybody can write a word processing program.
Well, I'm thinking about things like the mobile phones now, where there's certain debates going on about look and feel. So is look and feel classified as a manifestation or a subject matter?
The question in case it was picked up on the camera, the boom there, was to what extent does copyright interact with look and feel? The short answer is that part of the look and feel is protected by copyright, because particularly when we're talking about software programs, which of course is where the context of your question. Because, as I say, the law of copyright was extended by statute to cover copyright programs. When it was extended, it was also expressly extended to include preparatory works. Now, sometimes preparatory works can include look and feel. But the short answer is that's not the starting point, if that makes any sense. In other words, the fact that 2 programs have the same look and feel does not necessarily mean there's been a copyright infringement at all. But if you have, for example, screenshots that are very similar, then you can start getting into copyright infringement on the screenshots. But the mere look and feel is not, in the UK at least, necessarily copyright infringement. There was, many years ago, a big case between Apple and Microsoft. Yeah, it was Apple and Microsoft about the trash icon, and that was all about look and feel, essentially. But in the UK, there's almost no case whatsoever where look and feel has been successfully argued as the basis of copyright infringement. Probably what does copyright actually give you? Well, the right is actually in the name. It gives you a right to prevent people copying. Hence the word copyright. The right to prevent people copying. And not only the work, but also a substantial part of the work. What do I mean by substantial part? Well, there are 2 possibilities for substantial. Substantial can be either mean substantiality in terms of quality or quantity. Now, what on earth do you know that? Well, if it's quantitatively substantial, it means how much is it? If you copy 15% of the work, then that's a substantial part of the work. Courts have held that 15% is enough to have a substantial proportion of copying. So, if you think about a book, any random 15% is going to be a substantial copy. But also, you can have a substantiality test being satisfied qualitatively. What do I mean by that? Well, if you have, again, a book, but you have the conclusion chapter, which is maybe only 2% of the words in the book, but it's the key part of the book because it's the conclusions, and you merely copy the conclusions chapter, then that also will be enough to prove substantiality. So you can have copied a substantial part of the work, either quantitatively, as 15%, or maybe it's just a much smaller part, but it's qualitatively substantial. In either case, you'll have breached the copyright in the book in that example. And the same with computer programs or any other copyright work. And anything that you can think of doing with a book, copying it, making the book, issuing it, broadcasting it, anything of that ilk is a breach of the copyright. In the context of computer programs, it's exactly the same, and another example of copyright infringement occurs where there's a translation. In case of a book, translating it into French or Spanish or whatever language it may be, but also, of course, in terms of computer programs, transforming it from one language to another. So, for example, copying, taking the source code, compiling it, producing an object code is a breach of copyright if you do it without the consent of the owner of the copyright program. And copyright lasts a very long time. In the context of computer programs, one might almost say an obscenely long time, because it lasts for the duration of the life of the author, plus it used to be 50 years, now 70 years. A huge long time. God forbid we're still using Microsoft Windows in 70 years' time. Copyright exists for a very, very long time. If you think about, as I said before, copyright's been around for 200 years. The problem with extending copyright, as we have done to computer programs, is it's rather like trying to put the square peg into the round hole. You get bizarre results, and the only thing you can say is bizarre results. If you were sat down and somebody said to you, "Can you produce a fair right for people who write computer programs as to what their rights should be vis-a-vis the rights of the user of the computer programs?" Nobody in their right mind would produce copyright. It's bonkers. Why would anybody come up with a lifetime of the author plus 70 years to protect copyright? It doesn't. Computer programs. It doesn't make any sense at all. Why do we have it then? Why is it that we protect computer programs in the same way as books through the law of copyright? How long does it take? I talked before about Universal Convention and Berne Convention in the context of copyright. How long do you think it took to get those conventions, to have those conventions in various countries of the world? How long does it take to get an international convention? A long time, Christine says. How long is a long time? Anybody suggest?
50 years, 70.
50, 70 years? Well, maybe not like that, but certainly at least a generation, at least 20 years, a long time. If you think about that in the context of computer programs, there was no choice. If we hadn't forced the square peg into the round hole, by which I mean extended the law of copyright to computer programs, there wouldn't be any protection for computer programs. Because by the time you had governments sitting down trying to negotiate a fair right for computer programs, it would have been, I wouldn't say too late, but it would have taken a generation. It would have taken 20 years at least, if not longer. That's why we have the strange result of protecting computer programs in the same way as books and the other examples I gave you before, like photographs and sculptures, etc. We have this law of copyright also extended to computer programs, but it does produce, one can only say, strange results. And indeed, the essence of the law is the same no matter what sort of copyright or what sort of work you are thinking about protecting. It all stems from the Copyright Designs and Patents Act 1998, which is 88 rather, which is the primary law these days in respect of the law of copyright in the United Kingdom, and it's now based on a 1991 directive of the European Union, which was brought into force in the UK until 1992. And as I said, before this harmonisation within Europe, we had a decision in as long as 1985, or legislation I should say, as long as ago, 1985, which actually expressly stated that copyright will be extended to computer programs, but that wasn't the case in the rest of Europe. Greece, for example, it had been decided to the contrary, that copyright did not exist in computer programs. It was only following the advent of this 1991 piece of legislation that copyright was extended or unambiguously stated to exist in Greece, for example. And when you, there are some peculiarities about copyright when you do extend it to computer programs. For example, the legislation makes special provision where there's no human author. So for example, if you have a computer program that produces music, for example, people have written computer programs that produce music, the legislation says the person who, quote, makes the necessary arrangements, unquote, owns the copyright. Always amuses me as to who makes the necessary arrangements. In most places, the person who makes the necessary arrangement is the tea lady, without which the entity doesn't carry on business. But anyway, it's the person who makes the necessary arrangements. And in case of computer programs, even a transient copy is a breach of copyright. I'm using Microsoft PowerPoint to display these slides to you. I have a permanent copy of Microsoft PowerPoint on my computer, but of course when I make the presentation, as I'm now doing to you, a transient copy is loaded onto that, or certainly a transient copy of a substantial part of Microsoft PowerPoint is copied onto the random access memory of the computer program. There is an implied license from Microsoft that I can do that, because obviously I can't really use PowerPoint unless I'm able to do that. But even a transient copy is a breach of copyright. Put it another way, would be a breach of copyright without the consent of the copyright owner. And again, in the context of computer programs, there can be secondary infringement. What's a dongle? But people still do have dongles, interestingly, for computer programs, strangely enough. These are little things that usually go in the serial parallel port at the back, sometimes a USB stick these days. Essentially, the computer program, my wife has a sewing program which still has a little dongle. She has to put it at the back if she wants to use it. And what's the basis of the dongle? Well, essentially, the computer program runs and says, oh, I need a magic number in order to run. Where's the magic number? Interrogates the USB stick or the parallel serial port, wherever it may be, and if the dongle is there, it produces the correct magic number, and hey presto, the program runs. Without, if you were to merely copy the dongle and not the computer program, that is essentially also a breach of copyright without the consent of the copyright owner. And we also have something called moral rights. Again, moral rights are within the context of copyright, so I guess I should talk about moral rights. Moral rights are not really something which historically existed in the UK, but in 1988 we extended the law of copyright to include moral rights. Moral rights essentially are twofold. One is the right for an author to be identified as the author of a work of copyright, and secondly, the right of the author for the work not to be treated in a derogatory manner. However, it doesn't extend to copyright. It doesn't extend to computer programs. Of course, the two bullet points on this slide are: one, documentation. Moral rights do exist in terms of documentation. If you write documentation for computer programs, you can have moral rights. That's to say, the right of the author to be named as the author of that documentation, and the right of that documentation not to be treated in a derogatory manner. And secondly, Canada is an example of a country where, until recently certainly, moral rights did exist in computer programs. So if you ever see a computer program, a license or assignment of computer program software, copyright and computer software, that says the author doesn't claim any moral rights, that's why, because otherwise it can cause all sorts of chaos if you don't exclude moral rights. Who owns copyright? The person who owns copyright is the person who writes it. If you forget everything else that I say to you this evening, I guarantee that what I'm about to say next will save you some money. In fact, when I do my 2-day Dai Davis on intellectual property law course, which I occasionally do, I say to the people, how much do you pay for this course? And they say, depending upon who I've done the course for, anywhere between, I don't know, £750 and £2,000 or something of that ilk. And I say, right, I will save you that £2,000 by the very next statement I'm going to make you. And if you remember this, then I guarantee through the rest of your career you will more than make the money back. The person who owns the person who owns copyright is the person who writes it. So if you engage as a company, a programmer, to write a program for you, a consultant, an external consultant to write a program for you, who owns the copyright? The gentleman there is nodding. I think he's saying consultant. It's the consultant, it's the person who writes it, not the person who's paid for it to be written.
Except for the contract that's taken out.
Except for the...
Where there's a contract between the business.
Ah, yes, if there's that's an assignment and you can modify and change who owns it, but the starting point of the law is the person who owns it is the person who writes it. Of course, if it's written in the course of an employment, that's different. If a computer program is written or any other copyright work is created in the course of employment, then the person who owns it is the employer, provided it is in fact done in the course of employment. But where you have an independent contractor, an independent consultant, then it's that consultant, or perhaps the employer of that consultant, who owns the copyright, not the person who's paid for it. Now, it may be, as you say, Christine, as a result of the contract that's taken place, that there is a subsequent assignment of that copyright. But the starting point is it's the person who writes it, not the person who pays for it, that owns the copyright. And many a business, if I say to you now that probably 99%, maybe I'm exaggerating, maybe only 98%, but certainly 1 in 90% of all copyright disputes are about that point, are about people who've forgotten that that's the starting point. And they have arguments about what the contract did or didn't imply. Was it only a license, or was it an assignment of the copyright that was otherwise taking place? A very high percentage of disputes are about that. The strange thing about copyright in English law is that if you infringe copyright in the course of a business, then not only is it a civil one, but it's also a criminal one. Copyright, as I say, gives you a right to prevent copying. It's a negative right. Most intellectual property rights are a negative right. If you infringe somebody else's patent, or if you own a patent, it doesn't give you anything other than an opportunity to sue somebody who infringes your patent. If you own the copyright, it doesn't give you any more or less than a right to sue somebody who infringes your copyright. It's a negative right in that context. But if you also breach copyright, or the person has also breached copyright in the course of business, and that's the key phrase, then not only is it a civil one, but it's also an offence. 10 years imprisonment. Recently 2 years, but the Labour government, in their infinite wisdom, decided to extend it to 10 years imprisonment. Bonkers in my view. Why is it bonkers? Because what it means is that if you have an argy-bargy with somebody about what the licence is, going back to what Christine was saying, well, don't these people have a contract to, in the circumstances where A writes some software for B, and they have a contract, that's fine. How many contracts have you ever read that are unambiguous? It doesn't happen in real life. I mean, even I write contracts that, God forbid, sometimes I look back 5 years ago. What do I actually mean by that? It's very difficult, if not impossible, to write something which is completely unambiguous. You're dealing with a natural language, after all, English. Most lawyers get it right most of the time, but even most lawyers can't get it 100% right all the time. And of course, in contracts which are not written down, there's lots of ambiguity. That's why I think it's completely bonkers having 10 years imprisonment, because what it means is if you have a argy-bargy, a discussion, an argument about what does the licence say, and the person, the licensee, is actually in the wrong, then not only is it a civil offence, but also if the licensee is using it, because what is in commerce, in industry, then it's also a criminal offence. You might think, well, hang on a minute, does that ever happen in practice? You know, if I'm acting for a licensee or a licensee having a discussion, an argument about did the licence extend to 200 users or was it only for 150 users? Do people get into situations where they threaten criminal proceedings against each other in terms of copyright? Anybody ever happened to it? Has that ever happened to anybody in this in the room, or was it just me? All right. Why does it not actually happen in practice that people get into arguments and then threaten, oh, by the way, this is a criminal offence, what you're doing? The classic story is a case called Thames and Hudson. And in Thames and Hudson, Thames, if I remember correctly, was the book publisher and Hudson was a photographer. And to cut a long story short, what had happened was that Thames had produced this. It was like a glossy coffee table book with a lot of pictures in it, and one of which was Mr. Hudson's, the photographer's, sorry, Mr. Thames, that's the other way around, Hudson was the publisher. So Mr. Thames's photograph, and they had this copy. And then what happened was Hudson was going to produce a second volume, or second edition. And Hudson said, no, I want, if you're doing a second edition, I want a £2,000 licence fee, not a £1,000 licence fee if you're going to put my photograph in, because the first edition was much more successful than either of us anticipated, or whatever it was. And they were having a long argument about this, and then Hudson went ahead and produced the book, at which point in time Thames said, well, that's fine, I'm going to sue you, but I'm not going to sue you for copyright infringement, I'm going to take criminal proceedings against you for infringing my copyright. At which point in time, Hudson basically said, you can't do that. Well, I'm afraid you can do that, and that's what the court held pretty quickly, at which goes to point in time. I presume that Hudson paid whatever it was Thames was asking for in licence fees. So when I say, have I ever done this in practice, what I actually mean is, have I ever written to somebody saying, oh, not only dear sir, you're infringing my copyright, can I have £5,000 damages, but P.S., if you don't pay me my £5,000, I'll prosecute you, because anybody can prosecute anybody else in this country, that's the way our criminal law works, because you're breaching the criminal code of copyright.
Has anybody ever been in prison for a copyright?
Not as far as I'm aware. Not as far as I'm aware. But have I ever done that? Well, the answer is I've done it on 3 occasions in my professional career. When? That's a question I've got for you. When does it actually happen in practice? You know, most of the time people have lots of arguments. You know, I haven't just had 3 arguments in my professional career about licence fees and what's the appropriate licence fee and whether somebody's stiffed somebody else. You know the word stiffing? Not my word, by the way. It was invented by Computer Weekly about 15, maybe 20 years ago. I stiff, he stiffs, he. Sorry, I stiff, you stiff, he, she, or it stiffs. What's stiffing mean? You know what the word stiffing means? I'll say it's not my invention. It's the art of extracting licence fees from people when they weren't expecting you to be extracting them. So, like, you know, oh yes, didn't I tell you that if you wanted 10 users, not 5, I was going to triple the licence fee? That sort of thing. Certain companies, which ought to remain nameless given the audience that don't know listen to this, but I'll tell you afterwards, are quite famous for it. So lots of arguments about whether people are actually paying the licence fee that's actually due. Very few actually accelerate that to a criminal proceedings. When does it happen in practice? Well, the answer is when there is a breakdown. There's already been a breakdown, past tense, of the relationship between the parties. Usually where one party is in liquidation. So, for example, I'm acting for a liquidator, and there's no relationship going to last anyway, because the liquidator's job is just to get as much money as he can. So they've been having argy-bargy for 6 months, and then one of the companies goes bust, and then you just write and say, well, you know, that's fine, but if you don't pay me what I think you ought to, then I might just take criminal proceedings against you. And of course, that's not just against the company, you can't be prison companies anyway, that's also against the directors as well. So it doesn't happen very often in practice, but any breach of copyright, if it's in the course of business, is not only a civil offence, it's also a criminal offence. And as you can see, some pretty hefty penalties, 10 years in prison and unlimited fine for that. What's the purpose of a licence? Well, a licence is nothing more or less than a permission to do something that you otherwise can't do. The person who owns the copyright owns everything. The person who doesn't own the copyright has no right whatsoever. That's the starting point. The licence is a permission to the person who doesn't own the copyright that wants to use the computer program or any other copyright work to do what would otherwise be in breach of copyright, and be, as I say, not just a civil offence, but in the course of business, also a criminal offence. So the licence is fairly fundamental in terms of allowing what it is that people want to do in real life. And because it's a permission, you can restrict that permission any way you want. And typically, software licenses restrict people in terms of time. This is an annual license. If you want to use it in year 2, you've got to pay me another fee. Say the majority of software is not licensed that way. Majority of software is usually not licensed by time, but a good chunk of commercial software, 20-25%, if not more, is licensed still by time. You only have a license for as long as you pay the fee. Another way in which software is typically licensed is through a number of concurrent users, which I intimated at before. You can only use it for 5 concurrent users, not 10 or 20 or whatever. Or possibly by purpose. You can't use it as a basis of an outsourcing agreement. You can only use it in your own internal division or whatever it may be. Other forms of restriction are transferability. I'm only licensing you, and if you don't want to use it, you can't transfer it to me. Well, actually you can't. The starting point in European law is you can't do that. I'm not going to start talking about how people do or don't do it in practice. Suffice to say that it's not actually as easy as that to do it. I know lots and lots and lots of software licenses say this license is personal and can't transfer, is non-transferable, but actually that's not the starting point in European law. Actually, starting point in European law is all licenses are transferable, but people nevertheless do attempt to make licenses non-transferable. And of course, many licenses, most commercial licenses, are going to be subject to payment. The license is only valid provided the appropriate fees have been paid, and are terminable in many circumstances. Again, I'm not going to talk about that, but the starting point is, if you are the recipient of a license, the licensee, then you have no rights other than those granted to you in a license. And if I said to you, you can only use this software on alternative Tuesdays when you're wearing a blue hat, that's a perfectly valid license. You'd probably say, why on earth would I want to accept that license? That's a different question entirely, but it doesn't affect the validity of the license. You can license something however you want, because I own all the rights and you don't own any of the rights, except through the course of this permission. And of course, historically, that's where self-licenses were coming from. I own everything, you own nothing, and therefore I will permit you only within the confines of this license to use my software. Fundamentally, there's nothing different between those historic types of software licenses and open source software licenses. It's just that open source software licenses take a completely different approach to the way in which the software is licensed. The word open source has many different connotations to different people. It's very difficult to define. it's often associated with the word free. And I have deliberately not put the word free on the slide because again, it produces the wrong connotations. When people talk about free, and sometimes people refer to open source software licenses as FOSS, which stands for free open source software, or FLOSS, which is an even worse word, which is free liberté open source software, they don't mean free in the sense of you're not paying for it. It may well be, and many open source software licenses, in fact almost all of them, are non-payment, don't require a payment. But it's not, when they're talking about free, they're not referring to the payment methodology, they're talking about free in the sense of very little restrictions, or if any, restrictions on use. That's where the free it comes from. It's not the free in terms of payment, it's freedom to use. Open source essentially has to do with the way in which the software is licensed. And examples of open source are licenses which allow free redistribution. In other words, you do what you want with this software, you can redistribute it, you can embed it into your own code or further software products and redistribute it to your heart's content. You've got free access to the software, source code. You've got access not just to the object code, but the source code. You can do what you want with it. You can freely license derived works which you've developed based upon that software. Many software open source licenses require you, so this is a condition of the license, require you yourself, when you embed the open source software that you've had access to in other software works, to license those other works in a non-discriminatory manner. In other words, you can't say, well, I'm going to write this bit of, I'm taking this bit of bit of open source software, I'm developing something else with it, but I'm very green, so I'm not going to license it to the nuclear industry. Can't do that because the underlying license, the condition on which you had the software, didn't allow you to do it that way. And many open source software licenses are non-discriminatory in terms of the way in which you can deal with the software. The crux, as I say, of the meaning of open source is having open access, not just to the source code, but having an ability to use that software, very little restriction of use in terms of the license. And there are many drivers in the use of open source software these days. Object-orientated design, why would you reinvent the wheel? So there are lots and lots of, for example, mathematical algorithms that are available on open source software licenses. Why on earth would you want to say reinvent the wheel? Open source is incredibly prevalent today. We'll look at statistics in a minute. There are lots of other things which drive open source software, not least of which is that geeks like the concept of free access. And lots of computer programmers in real companies like open source software because it appeals to them on a philosophical level. Gartner did a survey about 4 years ago, and this was sort of top 1,000 companies in the world, and it did a survey and it found 85% of these companies, this was about 5 years ago, 85% of companies had used open source in their development software. And the other 15% were going to do so in the next year. Now, I don't know whether that means that today 100% of companies are actually using open source software development, but the prevalence and use of open source is incredibly high. There are many companies these days in the world that use open source. Some of them know that they're using open source. Again, Gartner reckoned that about 60% of them had actually no idea where the open source software was actually being used in the companies, because the developers in the companies didn't tend necessarily to go to management and say, oh, can we put this bit of open source in this particular code they're writing. But we all use huge amounts of open source in development.
Can you explain the difference between what you use as an end user, like using Microsoft Word as an end user, and use of open source in creating something that you may sell on? Because obviously they're different. You survey people saying they use open source, well, they could use OpenOffice, as you say, on there, and just an end user as an alternative product. But there could be people who are using bits of open source to sell on.
That's what I'm talking about. I'm
yes.
talking about the use of open source in the development of the products that those companies are being used, and that's what I'm saying. As far as one can tell, almost every country, every large company is actually using somewhere open source in a product that it itself has developed. That's what I'm saying.
And obviously there's a governance issue then, isn't there?
Yeah, absolutely. There's a huge governance issue.
Yeah.
And what I'm also saying is that the majority of those companies don't actually have a governance policy for the use of open source. Whether that's an issue, as big an issue as people make out, well, we'll do that in a few minutes. So there are lots of drivers for open source, but perhaps the biggest driver for open source is the fact that there are an absolutely enormous number of open source projects. I mean, with all of open office and things like that, but that's the tip of the iceberg. There are 180,000 more than open source projects, and it's growing exponentially, and has grown exponentially in the last 3, 4, 5 years. An absolutely enormous amount of open source stuff. And again, this is partly cultural. Does anybody know where the big continent is for open source stuff? Where most software is open source? I mean, we live in the Western world, as it were, where in fact most software is certainly not open source.
Sorry, Brazil?
Brazil, yes, South America. Brazil is a good example, but South America. South America, huge number of, it's a cultural, if you like, positive. Everybody uses open source in countries like Brazil and South America. 180,000 projects. Why on earth would you want to reinvent the wheel? The problem from a licensing perspective is that and I've deliberately been vague so far about what is an open source software license is, because there is no such thing as the or an open source software license. Why should there be? There are different forms of license. About 2,000 different types of license, of which about 1,400 are what you might call common, or at least more widely used. Different licenses people use in different circumstances. Some of them have a semblance of similarity, and as I've already explained, the essence of open source is allowing people to use this software in a relatively benign manner, with relatively few restrictions. And Apache, Linux, Mozilla, these are all pretty well-known examples of open source software which people use. And of course people not only use those, but they then base their own products on those open source products. Sorry, stop.
I was going to ask if a characteristic of an open source software license is that it has certain prevention of restriction, if you like, trying to, you can't disallow certain users, you can't disallow, there are lots of sort of protection against it being restricted. But if people are going to use chunks of open source code in their own products, then they are then going to put restrictions on. Doesn't that kind of go against what the originators of the open source were trying to do?
Well, precisely. Yeah, so the question you had is, if somebody who then uses the Mozilla Firefox or whatever it may be, and then use that to develop their own product, then in their own product has restrictions on it, isn't that going against the breach of the license? That's exactly right, and that's exactly the basis of the inverted commas legal issue. The real question is, to what extent are these licenses enforceable, or how can they be, what happens if they're breached? Well, before we answer that question, we're going to look at actually what the licenses say, which I'm going to look at in a minute. Even though, of course, I can't look at 1,400 or 2,000 or even 1,400 different licenses, because we'll be here forever to do that. The licenses are often called copyleft as opposed to copyright. That's another name you might come across for these open source software licenses, of which by far the most common is what's called the GPL General User License, which is associated with the logo on the right hand side there. And GPL license comes in fact in different forms, 3 versions in fact, 1989, 1981 and 2005, and a lot of software is based upon this GPL type software. And so people use this GPL licensed software and they use it to develop their own products, and then they try and not follow the restrictions, or indeed how the restrictions work anyway in terms of the open source software. Open source software licenses like to say that if you use this software and you use this software to develop other bits of software, then those other bits of software that you developed, you have got to make and you've got to allow other people to use in an open source manner. We'll look at some wording in a minute. In fact, let's look at it right now and look at what's called the Creative Commons license, which says you may distribute a public form an adaptation only under the terms of this license, or a later version of this license, or a Creative Commons. In other words, it's saying if you, an adaptation there is a development, if you develop some software using this software, then you've got to use this license or something similar to it when you propagate your end result, your adaptation to other people. In other words, it's trying to say that this license will not just apply to your use of the software, but it will apply to anybody who uses any development that you yourself create from this software. The breach, the license fee they would otherwise have got had you taken a regular license from them. There are lots of problems which owners of open source software have in terms of bringing cases against infringers. Number one, what have they lost? It's the license fee that they've lost. Well, of course, there isn't a license fee, is there? That's the whole point. Well, not the whole point, because say free doesn't mean free just in terms of payment. But in reality, most of this software license is licensed in inverted commas without charge, rather than free, without charge, and therefore haven't actually lost anything in terms of monetary value. We'll look at a couple of cases. The most important case is one in the United States. I say the United States because, in fact, there hasn't been any cases in the United Kingdom. But there's a very interesting and, I would say, famous case. It's about the only case that of any consequence on this point in the United States. And it's a case of Jacobson and Katzer. It's a 2008 case. And it's all about a model railroad interface written in Java. And Mr. Katzer had used this interface software in his own model railway system, which he then marketed to the public, and not, in essence, not taken any notice of the fact that he used open source software in the development of his own software, and had infringed the software license. And Jacobson sued him for the privilege, took him to the California Federal Court of Appeal, and Mr. Jacobson won. Or did he? Well, it was settled for $100,000. So you might say, well, that's pretty stunning in that case, that Jacobson, who was the person who owned this open source software, managed to get $100,000? No. Actually, Mr. Jacobson had more money than sense. He settled for $100,000, inclusive of costs. I've spoken to a couple of my US lawyer mates who assured me without much difficulty whatsoever that his costs would have been well in excess of $100,000 to take a case to California Federal Court of Appeal. So he made a point, yes. Did he make a profit? No. So yes, he did successfully enforce his open source software, but as I say, the question of more money than sense, I think, comes into it. Did he actually make a profit? No. And there have been some German cases as well, and French cases. Case of Welt versus Sitcom Deutschland, which was to deal with the firmware in a wireless LAN router. And an injunction was granted because Mr. Welt was able to show that his open source software had been included in the Deutschland GmbH, or the Sitcom Deutschland GmbH's product, wireless LAN router, and it was being offered on a commercial basis, and the software license had been not properly respected. The open source software license. Another case in Germany, Welt versus Skype. Oh, it's the same guy. Welt versus Skype Technologies. In the same sort of case. And another case in France, Welt versus. Hang on a minute, we've done that story. Why is it Mr. Welt all the time? You might ask. You might very well ask. That's because he's another guy with, I won't say more money in sense, but certainly he has an axe to grind. He is the person behind the GPL violations.org. That's him, basically, Mr. Welt. And he takes up, he gets money from various sources and offers to take up the cudgel. He gets people to assign to him their open source software ownership, and then goes along enforcing open source software, or has gone along historically enforcing open source software. In, as you see, Germany and in France. One of my competitors, and don't worry, I'm not going to embarrass them by telling you who it is, recently published an article on open source, and this is what they said. They said to the law firm, and they said, it seems surprising that there is not more case law available in Europe and the US, and even more expecting the lack of UK authority on this matter, i.e., why are there no English law cases enforcing open source software? In my view, it's bleeding obvious. The reason is, as I've already said, there's no money at stake. Mr. Welt got an injunction against Sitcom. How much? Of course, this was in France and in Germany. How much did it cost to take a case to a court in Germany? Anybody know? Take a guess. Answer is a few £1,000s. It's the way the German court proceeding works. It's very quick, very simple, very easy. How much cost it take to bring a similar case in the UK or US for that matter? A small fortune, yeah. Several tens of thousands of pounds. Nobody in their right mind is going to start enforcing open source software licenses, because what are your damages? You are not going to lose it. You're not going to get any damages whatsoever because you haven't lost anything.
I'm missing the point here. Why isn't there just a cost associated with the GPL that is waived on non-breach of use of that license?
Well, that's not that. You could license it that way. You could say that I license this to you for £10,000, but I will not collect my £10,000 provided you do A, B, C, D, E, and F. Historically, they're not licensed that way. I'm not going to stand here and say that one of these 2,000 licenses doesn't actually say that, but philosophically, very few will, because it really goes against the grain of an open source software license. But I've not read a open source software. There's nothing stopping you to say you can license something however you want. Whether you then categorise that as an open source software license is another matter entirely anyway, but certainly it's fair to say that 99% of open source software is not, as a matter of fact, licensed that way. But there's nothing to stop you doing it. You could do it that way. Now you might say, well, hang on a minute. In one of the cases, somebody sought to get an injunction. They did. They sought to get an injunction. And you might say, well, that doesn't require, you know, that's going to put a spanner in the works if somebody takes a case against, Skype in the UK, then they may not get damages, but they may get an injunction to stop them using that product in whatever it was, the router or whatever it may have been, the particular product that they used it in. And in those circumstances, maybe they would use that injunction as a lever to extract the damages that they would want in those circumstances. But again, if you think about practicality of that, it doesn't happen. Why doesn't it happen? Why won't it happen? Well, because if I was to launch an open source software case, almost by definition, the company would already put a product on the market. It would be not inconceivable, but highly, highly unlikely that you would get what's called a temporary injunction pending the court case being taken to court. How is it to get a court case in the UK to court? Well, we've got this speedy post-Wolf reform 2000, in the year 2000, Mr. Lord Justice Wolf, had this wonderful reforms to have speedy justice. How long does that take now? At least a couple of years. So, you're unlikely to get a hearing, or at least an injunction, in that interim period. There are certain circumstances where you can get a temporary injunction pending that full trial, but it's not likely for a variety of reasons that I'll bore you with in the case of open source software. So yes, in 2 years' time you might get an injunction. If the company thinks that the plaintiff is serious, if the defendant company thinks the plaintiff is serious and has actually got a good, decent case that the defendant company has breached open source software, what's it going to do in that 2-year period? Rewrite the code in such a way that it doesn't breach it. So, fine, you come to the end of the 2 years and you say, right, now we've got our injunction against you, come on, pay some dosh or we're not going to waive the injunction. You say, fine, doesn't matter, I've changed my code now. And yes, I'll give you damages for the infringement in the last 2 years. What are your damages? As I said before, what's the loss? Very difficult to prove there's any loss because it's been licensed without charge anyway. So that's the reason why in practice there hasn't been any litigation in the UK, and it's highly unlikely that there ever would be any litigation in the UK. Having said all that, there is nevertheless still some risk associated with the use of open source software, and some problems to do with it. I won't deal with dual licensing or free licensing. As I've already said, the fact that you're not going to get sued for open source breach of open source software, that just doesn't happen in practice. It's a nice theory, but except in some very weird circumstances, it doesn't happen. I've already mentioned the fact that in the US, the only case of any consequence was somebody who was actually out of pocket at the end of the case. And in the UK, it's never going to happen. In Germany, it has happened in some very strange cases, but those are, as I say, German cases which couldn't be repeated in the UK because of the way our litigation system works. The one issue that most people come across in terms of open source software is when you are buying or selling a business. That's the real problem people have with open source software, because they use open source software to develop something. And then 5 years, 10 years later, they come along to sell their business. And the buyer says, well, hang on a minute, you've used open source for this bit of software code. And you want £10 million for the business. Well, actually, we're only going to pay you £5 million for it. That's the problem that people have with open source. Coupled before with what we said, that most companies, the majority of companies that actually use open source don't know they're using open source, at least don't know where they're using open source. Now there are people like Black Duck who will, for a fee, look at your code and actually forensically look at your code, and they have libraries of open source software code which they compare it with to see whether you've actually used, or where you've actually used open source software in your product developments. But the real problem comes that most people don't always know where they've used open source. And then it comes back to haunt them when they want to sell business. And yes, they can, as you suggest, they can rewrite the code in such a way that it doesn't breach it, but they don't want to have to do that, if you like, when there's a gun to their head when they are selling business. Well, I appreciate that I've taken, as I estimated I would take to the gentleman in recording, 70 minutes telling you all this. I'm more than happy to answer questions. I think there's one other issue I'll just raise on the question of open source before we're finished, though, and that's the question of jurisdiction. The first thing to say about, has anybody here read a open source software license? Have you read one? Gibberish or not? Yes?
Yeah, you get past the first page and it says, well...
Yeah. Why is it gibberish? Why is most open source... Well, why is people anything like the GPL license gibberish? The answer is because it's written in transatlanticese, is probably the best way to describe it. In other words, it's written mostly from a US perspective, a lot of the US input, with a little bit of input from other jurisdictions, but it's mostly written from a US perspective, and US licenses, US agreements, such as licenses, are different fundamentally from UK agreements, or English law, I should say, agreements, because they're coming from a different standpoint. I mean, even English law and Scottish law agreements are different. So they're written from American perspective, with sometimes a little bit of a nod towards other jurisdictions, but mostly American. In fact, the GPL license is quite interesting because it's then been translated into it has been translated into Canadian law. It's been translated into English law. That was some of the GPL licenses, they're different variants. So you then look at you look at these variants and you say, fine, okay. But if you've got an American developer, US developer, who's developing some open source software, which form of license is he going to use? Because he's not using the English license, he's using the American license. And then you're in the UK using that software license. So you then breach that license, he's then going to try and enforce that license against you in the UK, so you're trying to enforce a US license in the UK. Well, even assuming that you manage to prove that it is actually the US form of license, not the UK, not the English law translation that applies to you, which is another question entirely, because some of these licenses are ambiguous on the point. But even if you manage to fundamentally say, yes, it is the US license that you've breached, you then got US law trying to enforce US law in the UK. Can you do that? Oh, yes, you can. Is it cheap? No. It's very expensive. Most times, most foreign law jurisdiction issues go into the too difficult box, 99% of the time. Nobody ever gets into foreign law enforcement problems unless they're shipping companies. Interesting, if you look at all sort of foreign law arguments about which law applies and all the rest of it, 90% of all the cases are all to do with impoundments of impounding of ships and bills of lading and stuff like that, where there's millions of pounds at stake. Nobody in their right mind is going to have an argument about trying to enforce a transatlantic open source software license. It's just far too difficult. Well, as I say, thank you for bearing with me and allowing me to talk for more than an hour. I'm delighted to answer any questions that you might have. But yes, you are on my team.
How does use of open source software in a product affect the enforceability of a subsequent non-open source license for that product?
How does
the use of open source in a product affect the enforceability of a subsequent non-open source license for that product?
non-open source software.
So if you develop a product and you use open source software in that product,
Yeah.
and then you release your product under you try and sell your product effectively, so it's not open source, how does the use of that open source software affect the enforceability of your license
Of your
subsequently?
license. In other words, can somebody who's infringing it say, "Oh, well, you yourself
exactly.
are in breach of the license"? The answer is it probably wouldn't help. It wouldn't help you, and the reason it wouldn't help you is because most of the time when that happens, you are using the open source software so that you don't reinvent the wheel. In other words, it's all object-orientated design, etc. So you've used a module, somebody else's module, but you've written your own modules as well. So the end result of the software is taking something old, taking something new from you, and producing a new product. And you've got layers of copyright, if you like. Think of it this way: you've got a book, okay, and you're the publisher of this book, and you've got 50 photographs in the book. You've taken 25 of the photographs from open source libraries. You can do what you want with those photos, and you've got 25 of your own photos in the book. You then license the book to somebody else. That's fine. The fact that you breached the license for the other, half the book, half the photos, is neither here nor there. Those people may be able to sue you, but that doesn't affect the fact that you created your own book with another 25 photos, 50 photos, or whatever it is in all. You're perfectly entitled to do that, and it wouldn't affect your enforceability at all, and you enforcing your license.
But the open source software you use says that any derivative works have to be released under an open source license.
Correct.
And that doesn't matter.
It does matter. You have breached it, but so what? That's what I'm saying. The fact that you have breached it.
There's no kind of implied
Exactly.
open source
I mean,
license.
go back to the Volt and Skype cases. It didn't mean that Skype had to say that all the people who had used their software, oh, you can have it for free, or well, not free anyway. But, there's no license stop. It didn't mean that their licenses were enforceable, because they'd still written their own software, which, together with the software they wrongly appropriated, if you call it that way, nevertheless was a new software product which they were perfectly entitled to license, even if they breached in so doing the open source software license.
In those circumstances, could the seller of the new additional software, the enhanced software, could they claim that they were selling at a reduced cost because they weren't charging for the open source software? And they would have cost more had they not used the open source software because they'd have had to write their own instead. Would that be a legitimate argument?
I mean, that's why people use open source software. People use open source software because it reduces their development costs. I can't see why the purchaser of the end product would want to argue that it would cost him more if the vendor hadn't used open source software. So I can't actually see where the argument would come from, if that makes sense.
I think what's more likely to happen is software is going to come cheaper. You're
Yeah.
going to sell it for services and for support services
Which is
later
another-
on,
another-
which is people like Red Hat have made an absolute fortune by using open source software by selling services and training,
Yeah.
and that's, I think, is the way the market will go. I agree with the gentleman there. I try very hard to try and make sure the open source and the bespoke driven things are kept very separate, so you potentially haven't polluted licenses, but it's getting harder and harder because, as you say right early on, the geeks want to use it, and it's very hard to govern what they're doing.
Quite often
And you don't know you've got black duck, and it's
genuinely very
yeah.
difficult to know if it's being used in the code.
particularly if they use bits of it as well. They're not using the whole product. It's cutting and pasting,
Exactly.
and it's impossible to track.
Which is so why people like Red Hat make money, because they can forensically look at lines of code and say, oh yes, those 3 lines of code are being whipped from Java or wherever it's come from. And as you say, if you're trying to write some algorithm, oh, didn't Java do that in there, whatever it was, and you just stick the code and put it in your product. Very easy to do. If you're a developer, as opposed to a manager, if you like.
So I've got a question, I've got a statement. You've actually highlighted for me that some years ago I actually had a case if I'd had the knowledge to pursue it. Because I spent 14 years working freelance. And one of the contracts I had for a year, I worked for one of these wonderful government over cost, over budget projects. And I was the quality manager, and I had to write in civil services how you actually did a quality control check of each section of your development as you passed it on to the next team. And I actually worked in tandem with the civil servant, and we got the document approved. It got authorised. I went on holiday. When I came back, it had been printed and distributed with major changes, which didn't have the civil servant who changed its name on the document, went out in my name. And I actually blew my top with my line manager, who sat there in total ignorance and said he didn't even know it had happened until I actually put the two documents down side by side, and even then he just grovelled. But with hindsight, I was furious at the changes that had been made, because the context changed.
Yeah, well again, I don't want to talk about your case particularly, Christine,
No.
for two reasons. One is because, again, moral rights in the context of employment, moral rights don't exist necessarily in the context of employment. And secondly, in the context of the Crown has all sorts of funny rights in terms of copyright. Yeah, one of the issues I didn't touch on in terms of open source software is the impact of patents, because sometimes people have tried to get round open source, and the GPL Level 3 license attempts to do this and attempts to deal with this and ties itself to the knobs trying to do it. As to what happens if somebody says, well, yes, okay, I may have breached, I may have incorporated your software, your copyright software into my product, but my end product is also, my software is protected by patent. Well, again, the starting point in law is you can't necessarily take somebody's patent rights away from them, necessarily. So again, the question arises, can you enforce, to what extent is it anti-competitive to enforce your open source software license? So where you've incorporated your product, my software, which is open source, into your product, and you've now licensed this in breach of my open source software license. But I actually turn around and say, well, yeah, that's fine, but I'm not actually interested in your copyright. I'm protecting my end product because it's patentable. Well, again, suffice to say that that's not actually being litigated. There's a couple of issues that have arisen on that, but it's never actually come to court in a proper case yet. Some of it, let's say the GPL Level 3 license, attempts to say you can't do that, but whether it's enforceable is another question entirely. Sorry, that's struck me down.
If I produce something under an open source license and therefore grant people rights that they wouldn't otherwise have had, and they do something in breach of that license, yet I have no meaningful redress against them, what was the point in the first place? Why would I bother actually producing a license at all?
In other words, why don't you just say, I'm not interested in trying to have any license whatsoever, you can just do what you want with it. As far as I'm concerned, I'm not tempted to have any restriction whatsoever. The answer is yes, why wouldn't? That's the issue with open source software licenses, that they are in many cases unenforceable. So you could take that. And of course some software is in fact made available without any restriction whatsoever.
I mean, I understand that there's a spirit of community, getting a warm feeling out of it, but from a sort of legal point of view, it does seem slightly pointless.
To be fair, as I said, there are 180,000 open source projects. That was the description going on when I last checked. Probably more than 200,000 these days, because it is growing exponentially. And from a project perspective, you're dealing with more than one person developing this software. I mean, Linux is written by Torville Linux and names, but of course he only started it. Loads and loads and loads of people have written Linux since then. And most of the software is being written by a body of people, so it's not so much what an individual wants to do, it's what the body of people want to do. And the body of geeks would have it that you'd want to open source software. So yes, I accept in your question where in your question you said you developed some software, then why would you do it that way? But if it's being done by a project, then people will do it the way it's always been done, which is using open source, one of these 1,400 different types of license.
But there are also a couple of valid points on that. The reputational risk to the company that breaches the license is horrendous. The company that Microsoft doesn't like to be called the bad boy by breaching those rights. So having no license there at all would enable them not to breach it. And therefore the people who own that.
Yeah, I mean, yeah,
And-
okay,
and
there could
sorry.
be reputational risk here, but I mean, you know, had anybody here really? Had anybody here heard of the Volt versus Skype case before I matched to it?
And secondly, many of the products that you're showing, even on the board up there, are actually owned. They're developed by an organisation rather than the group of developers in the en masse world. And those people still provide that software under open source licenses and still make a lot of money, as was said before, like Red Hat do, out of support,
Yeah.
as do Alfresco, as do
Yeah.
Drupal. And therefore it's not just a community developing software and can't have any one individual who can claim redress when a license gets breached.
But again, Red Hat Linux is perhaps a special case because it's atypical of the sort of projects, the software development projects that are at, you know, we're talking about 180,000 open source software projects. We're talking about a huge number of different bits of software code here, there, and everywhere, most of which you and I have never heard of.
But the ones that businesses are they're going to be using the Red Hats, the MySQLs,
Those.
the big ones, the
The
patchy
XP.
ones that have got people, organisations behind them, and then they're becoming, Microsoft does open source as well. So, you know, you're starting to get the bigger groups. It might have been started with one or two people, but now you've got bigger corporations, and it's no different to Oracle might have been 10 years ago.
I mean, Microsoft. There have been allegations that Microsoft have breached Unix code, but so what? Does that really put Microsoft in a worse light to us? It's so used to litigation for a whole host of reasons.
I think you're watching
I
that.
can't really believe that anybody thinks less of Microsoft because Unix let it go.
I think the biggest thing is if you think about Sun were very much into open source, then they've been bought by Oracle. Oracle are interesting, and Oracle, then they commercially were changing licenses every other week. MySQL is becoming things. Java's changing as well. You know, you can get sucked into open source, and then suddenly you know it was like that last week, and then suddenly you've been caught, and you know.
But in that case, the projects can fork, can't they? Like,
well, yes.
like with MySQL.
Yeah,
Yes.
you end up producing a dual product, one of which is based on open source and one of which isn't, which is well. Trend, if that's the right expression. So if you've been hanging out with
Yeah.
So, yeah, Dai. That's right. Just to turn it round slightly, we've all got the sort of litigation from the open source to the person who's using the software. I just wonder if there's any reverse channel, as it were, in terms of any implied fitness for purpose. So, if you use your lovely open source maths library and stick it in your UAV drone, which then falls out of the sky in 3 months' time, is it effectively entirely your fault that there was some subtle bug in this open source maths library?
No, I mean the short answer is that if you are, if I mean most of these licenses say it's as is, we're not liable, but that doesn't necessarily achieve the goal that people are trying to achieve. In other words, just because you say you're not liable doesn't actually mean you're not liable.
Yeah, that's what I was thinking.
Certainly, if you're looking at English law, and again that's perhaps a false approach, because as I said, many of these open source software projects stem from South America, where I don't know what Spanish, Portuguese law, historical law says. But certainly the approach in English law would be if you are putting something in a stream of commerce, which you would be even if it's on an open source basis, then there would be a liability for not writing it if it if it was not of what's called satisfactory quality, which basically means relatively bug-free, then there would be a liability.
Even if they hadn't actually charged.
Even if they hadn't actually charged for it. The threshold may be less, but it's certainly not. It's not non-existent. In other words, if you buy a Rolls-Royce car, you can expect fewer defects in it than if you buy a Mini. Or put it another way, you can have more defects in a Mini and it still be of satisfactory quality than if you had that same number of defects in a Rolls Royce. The Rolls Royce would not be of satisfactory quality. So certainly cost is a factor in what constitutes satisfactory quality in English law, but just because something's free doesn't mean it can be a load of rubbish. In other words, there can still be liability.
Thank you.
But there again, would you ever find the person who'd actually written that bit of code, and would you ever be able to sue it? Would it be worth it? He or she would have to be worth anything, sue it. Can't get blood out of a stone, as they say. Did you?
Well, I was only really going to follow on what this gentleman was saying about what's the point in the software license. I'm actually a software developer, and I found open source to be useful not from protecting copyright, because I think, as you ably made the point, it's very expensive to pursue, and if someone steals your code, they're really not very worried about it. However, I have found that it's quite useful if I'm negotiating in, say, a government contract, and I would like to be able to reuse my own work. And rather than having to assign all of my rights in the work, I very often negotiate to have it released as an open source project or elements to be under an open source license, thus giving me legal protection to be able to reuse my own work at a later stage without having it strong-armed off me. I found that useful.
But I suppose the difficulty would be then if you wanted to use it as the basis for a future product for yourself, and you wanted to charge somebody for that future.
Well, again, that's where you get into the subtle licensing for the eventual product.
Which is why, I skipped over the words dual licensing, but sometimes people, in your position will dual license it. They'll say, well, actually, I will put it on the open source, but actually I'm still retaining ownership, and therefore the right to produce commercial.
Yeah, I usually have a
it's a
clause.
non-exclusive open source software license. So you're reserving the right yourself to use it in commercial circumstances, something like that. Should you want to do that? Go on. I will be here clearing you up if you've got any questions later.
We seem to have reached the end of this bit of the question session. Dai, thank you so much. I mean, you've taken a subject which I think has more than its fair share of grey areas, and managed to make it, turn all the complexities into kind of things that we can understand. And I think more than anything, I think that's been proven by the depth of the questions from the audience, how much we have actually understood how you managed to make such a complex subject so clear and really just interesting. And we just want to thank you so much for doing that, and for all the effort that you put into this talk and for the many, many talks you've given us before. So we just like to thank you, Dai.
So, what did you feel about this talk today?
Oh, really, really good. Dai's got a wealth of experience in a whole range of issues, crossing the technological and the legal divide. So this is a really good presentation today that, as the after speaker said, was all about bringing it to life in layperson's terms. I think it was really good the way he's done that.
Thank you very much. Thank you. Yes. So, talk to us about this conference. What did you think about it?
I thought it was very good. It's interesting to hear open source licenses being discussed in a sort of professional context, because I think, as was mentioned, it's been bubbling up in the computer world technically for quite a long time, and I think people are starting to discuss it at quite a high level now, and talks like this I think help bring it into the mainstream.
Hello, I'm Ramohan. I'm the chairman of the Manchester branch of the BCS, the Chartered Institute for IT. The branch covers the area of Greater Manchester, has about 3,000 members, and put on all sorts of events, including the event tonight.
Great. So what did you feel about this event today, particularly today?
Well, I think Dai's talks are always informative, lots of interesting, deep questions, which is always good to hear. The audience seem to participate and get involved with the talk, so I was very pleased.
And what's the future meetings? Is Dai going to be talking more about this in the future, or?
There's no future plans for Dai to talk about this. We may do a follow-up. I know Dai always does a yearly, one event from every year. Next year he's talking about the Internet of Things, which could be very interesting.
Well, thank you very much for your time.
Thank you.